So it works.
It should
Okay,
work.
well, let's see what the quality is like. Well, ladies and gentlemen, thank you for listening to me today. This is an exploratory lecture. It reflects the thinking I have had about law and economics and arbitration over the course of a number of years, and it's going to try to pull together a theme in law and economics together with the practice of international arbitration. That's the idea. I ought to say this, I'm not going to be offering any answers today. It is exploratory, what I'm saying, but I hope it will motivate reflection, possibly even some empirical research. And I'm going to have at least one strong conclusion, but probably not more than one. What I'm going to be talking about is public choice theory. So the first question is, what is public choice theory? I ought to say this, it's a controversial branch of economics. It seeks to apply the insights of economics to the activities of government, and therefore make economic methods a form or a branch of political science. That is what it's trying to do. What are the insights of economics that public choice theory tries to apply to political science? The principal such insight is that to understand how a change may influence the operation of an economic actor, we look to the actor's incentives. What is in their best interests? And public choice theorists say that government actors, that's to say legislators, members of the executive, and members of the judiciary, all act in accordance with incentives. They all have incentives upon them, and if you change their incentives, you change their behaviour. The original public choice theorists who used the phrase were James Buchanan and Gordon Tullock, and they wrote, I believe back in the 1960s, a book called The Calculus of Consent, Logical Foundations of a Constitutional Democracy. The idea in that book was that politicians in democracies buy the votes of other politicians by promising to vote for their issues in exchange for voting for each other's issues. And this is sometimes called log rolling or pork barrelling even. And then when groups of politicians accumulate interests through third-party funding or through internal self-organisation, then those are called special interests. And special interests are often more effective lobbyists because their transaction costs are lower. A transaction cost is the cost of doing business in an economic transaction. Because they're more effective, because it costs less to get a special interest group to form an agreement, special interests are better at pushing their agendas through democratic and constitutional mechanisms than individual interests. In a perfect democracy, there should be no special interests, but there are special interests, and they are reflected in the fact that governments create policies persistently that reflect the special interests of particular groups. And the better organised and better funded a special interest is, the more likely it is that it's going to get its legislative or government agenda through the corridors of power. A classic example of a special interest is the gun lobby in the United States, for example, which is organised to protect the Second Amendment and results in judicial, legislative and administrative action relating to the support of the Second Amendment, notwithstanding the principled positions taken by some politicians and members of the administration, which are essentially contrary to gun rights issues on points of moral or legal or political or ethical principle. So that's if you like, the origins of public choice theory. I'm also interested in the theories of bureaucracy of Max Weber and Ludwig von Mises. Why? Because I see them, in some senses, as being prototypes of contemporary public choice theory. The basic idea that both of these thinkers had, although in different contexts, von Mises was a substantially greater critic of bureaucracy than was Weber, who was writing at a later time, is that bureaucracy is by its nature inefficient and expansionist. They said because bureaucrats have incentives to develop their own empires. If you like, one sort of special interest is bureaucracy. Weber said the following. He said, bureaucratic administration means fundamentally domination through knowledge. While an indispensable threat to individual freedoms, an ongoing, relentless bureaucratization leading to a polar night of icy darkness, in which increasing rationalization of human life traps men in a soulless iron cage of bureaucratic, rules-based control. He was a wonderful writer, but the idea is that bureaucracy and administrators and executives themselves capture power, and they take power away from other branches of government, and indeed from individuals, and they grow systems of rules which they say are exclusively in the province of their area of expertise. Mises also thought that bureaucratic special interests were so strong that they eroded the legislative power altogether and engaged in the transfer of power to agencies and to the executive away from the legislature. His 1944 short and excellent book, Bureaucracy, talks about this. It's also a beautifully written book. For some reason, these libertarians were absolutely brilliant as writers, whatever one thinks of their ideas. But the idea is that the special interests push of bureaucracy are so well organised within the governments that they push through their own agenda, and the incentive of a bureaucracy is to expand itself. So while it operates under the pretense of a principle-based, rules-based administration, in fact, its real incentives are self-aggrandizement and capture of power. More recently, public choice theory has been written a great deal about in the University of Chicago, of which I am an alumnus. I think that the best book on this subject is that of Sam Peltzman. It's called The Growth of Governments, and it's one of the principal treatises of public choice theory. And the idea that Peltzman and a number of others convey is this, is that politicians and bureaucrats and judges are supposed to act in the interests of the general public as their agents, but they suffer from what economists call the principal-agent problem. Agents act in their own best interests, which may not be the best interests of the principal. The key to solving the principal-agent problem is to find a non-distorting incentive scheme for agents, so that agents and principals' interests are co-aligned. The classic principal-agent problem is lawyers and clients, of course, because lawyers are supposed to act in their clients' best interests, but their best interests are billing, and therefore spending as much time on a matter as possible, and therefore restructuring the way lawyers charge clients from by the hour to success fees, for example, is supposed to be a way of solving the principal-agent problem for lawyers. Simply asserting that lawyers always act in their clients' best interests because they have ethical rules which compel them to do so, I respectfully suggest is not a very satisfying answer to the principal-agent problem, because it suffers from exactly the fallacy that the Weberian bureaucrat or the Misesian bureaucrat suffers from, which is namely that they hide behind a set of rules when in fact what they're doing is capturing still further power and influence in accordance with their own self-interests. Alignment of interest between principal and agents in the context of public choice is difficult. Why is that? Because a lot of government agents won't do anything unless they are paid a market rate to do it, because they're paid the same nonetheless. And what generally economics says is that men as rational actors want more money. So, applied to public choice, if you're trying to align public agents supposed public agents supposed to be acting in the public good and their own principles, which is the general public, all of us, then you need to make sure that government agents are paid a market rate to act, to perform their duties. We call this a bribe. Public choice theory has also been applied to judicial thinking. My suggestion about one of the best examples of this, although he might not agree that he is a public choice theorist, or he might, I might ask him one day, is Richard Posner in his book How Judges Think. One of the best studies, I think, of the incentives that drive judicial thinking. His thought is this: in a tolerably non-corrupt system, judges are motivated principally by prestige and the desire to be recognised, and also by the desire to do the minimum amount of work. This is obvious because judges' salary differentials are mostly marginal and they do not get paid by the case. They get paid the same, no matter how many cases they do. Therefore, the incentives upon them are that they may want to write judgments that get reported publicly. They may not want to write judgments that are successfully appealed. They may want to write judgments that are not successfully appealed, the opposite. Why would they want to do any of those things? Because they may want to be promoted from a regular trial judge to an appellate judge, to a Supreme Court judge. How do you do that? You obtain the respect of your peers. They may want to dispose of cases as quickly as possible, to show that they do not have, quote, bad statistics. They may therefore be prone to procedural or jurisdictional determinations of cases, as these take less time and less effort. Judges may encourage mediation and settlements, because then a case can be resolved and removed from their case docket without their efforts, or with much less of their efforts. And judges may try to capture resources, such as junior lawyers, to do their work for them. This is particularly seen in the United States, which has a massive clerkship system. So you are told that being a judicial clerk is very prestigious and poorly paid. And you write the work, you write the judgments, and that's the way American judges manage docket pressure. In many countries, the judges have to write the decisions themselves. So the docket pressure is correspondingly more painful for them. In England, that's traditionally what has happened, for example, but now we've seen an increase in judicial clerkships. Why? I suggest for precisely the same reason as we saw an increase in them in the United States. Judges may wish to fight for politically important cases that they can decide in a way that is pleasing to those who may promote them to more senior judicial office. And they will also covet roles in which they can decide case allocation to other judges, since this represents a form of power or control over who they promote, over who they support, who they may want to put down. In other words, all the things that motivate bureaucrats in the absence of financial incentives. That's in a tolerably non-corrupt system. In a tolerably corrupt system, judges' incentives may be different, which is simply to obtain as many bribes as they can in order to decide cases. So in a relatively corrupt system of law, judicial incentives are very different from in a relatively uncorrupt one, in which there are no financial incentives upon judges whatsoever. The pay differential between a High Court judge and a Court of Appeal judge in England and Wales is very small, particularly compared to the income that judge may have received as a practicing lawyer prior to their judicial appointments. So that's the way that public choice theory might be considered to apply to the operation of the judiciary. Now, public choice theory is controversial. People don't like it. They don't like it because governments are supposed to be good or principled or law-abiding or whatever fictitious labels governments invent for themselves. And public choice theory is premised upon an assumption that that's not right and that government actors are just as bad as the rest of all of us rational economic actors and are just going around pursuing their own self-interests. And government's not supposed to be like that. So it's the infringements of economic logic into a sphere where it's not conventionally considered to apply. That's why people don't like public choice theory. It is, its critics say, simply too cynical an account of human nature to be of any use. Amartya Sen parodies public choice theory with the following beautiful scenario. A stranger comes up and says, "Excuse me, can you direct me to the railway station?" The local replies, "Certainly," pointing in the wrong direction to the post office. "And by the way, would you like to post this letter for me on your way?" The stranger replies, "Certainly," resolving to open the letter to see if it contains anything worth stealing. Now, I am not persuaded that that sort of clever, but I have to say somewhat cheap criticism of public choice theory is justified. The reason why not is that economics is a science of the margins, and I want to explain what I mean by that. It does not deny all human decency. What it does instead is it works upon an assumption that where we are trying to establish the result y of a change to the rules x, we rest upon the assumption that rational economic actors pursue their incentives and their self-interests. It's not saying that all of us are perfectly rational and perfectly self-interested all the time, that the entire world is a planet of 7 billion rational psychopaths. What it's saying instead is that it's accepting that there is a spread of human behaviour. Some people are rational psychopaths, some are irrational psychopaths, some are just selfish, some are irrationally altruistic, and some are rationally altruistic. But it tries to create a model where it says if you change things at the edges, then you try to predict what will happen by using the assumption that most people are, for most of the time, rational and self-interested. So it's a discipline of the margins. In my view, there is too much in economics which consists of what I call theoretical economics, and you can always tell this because you open an economics textbook and it's full of mathematical symbols, which seems to take assumptions about human nature and derive them into universal laws. There's far too much of that, and there's also far too much of what I call woolly economics, which is where people write extended treatises on economics, which talk about how people ought to behave or should behave or might behave in rather ambiguous ways based upon anecdotes. What economics ought to be is a science, and I mean an empirical science. That's my view. Without it, it's meaningless. As A.J. Ayer pointed out, if you don't have any verifiable hypotheses, your science is not a science. It is meaningless. It is about nothing. Because the sentences you are saying cannot be proven true or false. They're empty. So, in my view, what economics ought to do is it ought to create predictions about people's behaviour at the margins based upon certain assumptions about human nature. And then it ought to create verifiable hypotheses. In other words, if we change X, some institutional rule, then Y will come out as a result. That should be the goal of economics. And that should also be the goal of public choice theory. Public choice theory should not be rejected out as outlandish, simply because it reflects what certain people would say is a cynical view of human nature. It ought to be considered as a hypothesis to be tested. So it creates models, it creates predictions, and we test them. And if we work to a series of cynical or self-interested or incentives-based assumptions about the operation of judges, for example, then that should create predictions, and those predictions can then be tested. So the work of economics, in my view, should be empiricist in its nature. Now, how does any of this apply to arbitration, you might ask? Well, one simple answer might be that it doesn't, and that I'm barking entirely up the wrong tree. Arbitrators are not public officials, they are market participants. Therefore, public choice theory doesn't apply. That is a totally unsatisfactory answer. I'm throwing it out as a canard just to shoot it down, if you like, if I'm mixing my metaphors. If arbitrators are pure market participants, in other words, they're privatised dispute resolvers hired by the parties, then the Sen critique of public choice theory can't apply to them at all. If they are mere rational actors, like the rest of us, then the most controversial assumption of public choice theory, namely that public actors act like private individuals, disappears altogether, because we're accepting that arbitrators are private individuals, and therefore they fall into the rotting basements of regular classical economic theory. One view of arbitrators, and I say it's one view, might, and I'm going to throw it out as a hypothesis, because I want you to think what's wrong with it, if anything. One view might be that arbitrators are inherently biased. They're uninterested in applying the law correctly, and they're interested in becoming only as rich as possible through deciding cases in the interest of the best paying or wealthiest parties, so as to aspire for the prospects of reappointments, because arbitrators don't have tenure. On this view, imagine I was right. I can't be right. Right? I'll tell you why not. This hypothesis can't be right, because if that was right, then nobody would arbitrate except the rich when thrashing the poor, which does happen. This is like in cases where employers write arbitration clauses into employment contracts, and the employer has an unequal bargaining position with the employee. This has happened a lot in the United States. It's considered to be an abuse of bargaining power. It's been most exposed most fundamentally in the US literature, and in a number of US states, arbitration clauses in one-sided agreements like employment contracts are now considered void. So if I was right that arbitrators are all as bad as I described in this hypothesis, then the only people who would insert arbitration agreements are people working in these sorts of grossly one-sided abuse of power type situations, and then it would be a game of the legislature catching up with the abuse, and on it goes. But in fact, other people arbitrate. So I can't be entirely right, can I, in my hypothesis? But for arbitration to survive as a discipline with any integrity whatsoever, it has to embrace the notion that there is at least some public quality or public good that arbitrators represent or embody. Because if not, if that assumption is not correct, then my original hypothesis must be right. And we've just suggested that it's not, so therefore there must be some public quality or public good that arbitrators represent. They are not purely private market actors. They are something else. And as soon as we accept that there's something else, public choice theory comes into play. That's my idea. Now, arbitrators are private market actors in the following sense, in that they're paid for their work by the parties who want them to do a job of dispute resolution. In that sense, they can expect to be crudely incentive-driven on a profit basis. The better arbitrators do, the more likely they are to be reappointed, and hence the more likely they are to receive more money. That's what private rational actors do, according to classical economics. But the question is, to develop our analysis about arbitrators, is what does better mean? Certainly, it has something to do with the administration of justice as a public good and not just as a private commodity. And I'm going to suggest there are a number of indicators to that. For example, 1. Refusal to enforce illegal contracts, or contracts that are contrary to public policy. Those of you who've worked in investor-state arbitration will know this principle from a case called World Duty Free and Kenya. You can't enforce a contract based upon a bribe. Secondly, minimum standards of due process, contained in institutional rules or curial laws, or orders of the tribunal itself. Thirdly, regulation of the arbitral process by courts and international treaties, even if that level of regulation is in itself, in practice, marginal. Some of you may have followed the debate after the Lord Chief Justice, Lord Thomas, gave his speech on the 21st of March 2016. His complaint about arbitration, in a word, is that it's destroying the common law. Why? Because people are arbitrating rather than litigating, and hence there aren't any reported cases anymore. So the common law as commercial law is not being developed. That suggests that there are public goods that relate to and interact with decisions to arbitrate. To be sure, there are dispute resolution mechanisms that have no obvious public good element to them. I'll give you one example. There is a visa arbitration scheme between banks and retailers. The visa arbitration scheme kicks into place when you ring up your credit card company and say, the goods were the product I bought with my credit card was no good. They're defective. So let me tell you how that works in practice. The credit card company, the bank, in effect, they have a system in place where they write you a series of letters saying you're wrong, and they're all written by computers. Okay? And then, after a while, the bank doesn't care whether the goods were defective or not. Okay? Because the cost of investigation is almost always going to be more than the cost of the goods. They just mustn't tell you that. And therefore, the banks need to make sure I go to prison, so I can't talk about this. But after you've written a few letters, they automatically give you your money back. Then what they do is that they send all the correspondence between you and them to the retailers, and the retailers have an opportunity to read it and provide their comments or observations. And then that whole file simply goes to lawyers who call themselves arbitrators, but there's no hearings, no pleadings, no nothing. They just read through the file and decide retailer, bank, and they write on the bottom. No reasons. Then they hand it back. And that's how the disputes between retailers and the banks are resolved if you kept on complaining enough. Now that system has no public good in it whatsoever, but it has an obvious private good, which is that the cost of resolving these silly disputes about your £50 camera or whatever it was you bought on the internet and it doesn't work, the cost of resolving those disputes are far higher than the amount at issue. And therefore what you need is an extremely efficient, even if totally unfair and on occasion arbitrary, system of dispute resolution. And some clever soul might one day bring a claim under the Arbitration Act disputing all of this. But of course they never do, because it's an indefinite repeat play game, and it's the fact of a simple resolution is much more important than the justice of the individual resolution, given a volume of cases over time. You just need a system. There's no public good I can see in that, but there's certainly private good, and people keep using it, so everybody's happy. Let's proceed. If I'm right, and there are public elements, substantial public elements, to the job of arbitrators, then let's proceed with a potential public choice theory incentive-based analysis of arbitrators' behaviour. Now, these are not assertions by me about how arbitrators behave. They're hypotheses that one might draw from applying public choice theory to the operation of arbitrators in the way I've described. One hypothesis we might proceed with is abandonment of the purely theoretical presumption that arbitrators are independent and impartial. A little secret, quite a lot of people in legal practice don't believe this anyway, although nobody will admit it, since it serves the Weberian function of keeping the fiction of rules and principle-based activity alive. Another assumption, another hypothesis, party-appointed arbitrators are inclined to lean in favour of their appointing parties, securing reappointments from the same council in exchange for their loyalty to their, quotes, clients, close quotes. Now, every arbitrator in the world will tell you that that never happens. They have to. Do they? Do they? In the United States, it is possible, and it is occasionally found, that the presumption of independence and impartiality for party-appointed arbitrators is expressly removed. So there are systems of arbitration in the United States where arbitrators are in. It is assumed that arbitrators are going into bat, to use a cricket term, for the party that appointed them in the arbitration room. And that is consistent with US curial law. Even more, the possibility of ex parte communications between party-appointed arbitrators and their appointing council. Are those good things to change? Are they good things to allow? Should English curial law, should Swiss curial law permit such things? Right now they don't. Should they? If you change the rules, do you improve the behaviour? That's the sort of question that public choice theory asks. But it seems to me that the answer to that question, should we permit what US curial law permits about the behaviour of party-appointed arbitrators, should we abandon the assumption, or permit parties to agree to abandon the assumption of independence and impartiality on the part of party-appointed arbitrators? That is a question that is deserving of empirical analysis. We cannot resolve that question in this room simply by discussing what we think arbitrators are, or should do, or should be like. That's not going to get to the bottom of the problem. What we need is empirical analysis. Another assumption, or another hypothesis, that public choice theory might apply to the arbitral process. The chair of an arbitral tribunal is loyal to the arbitrators who agree to appoint him, probably leaning to the arbitrator who is more likely to be appointed in the future by council, and therefore is more likely to propose them and agree them as chair. As you know, in many cases, chairs are chosen by the arbitrators themselves. If the arbitrators are given the opportunity to choose a chair, generally they are able to do it, unless the arbitrators chosen are one or more of them outrageously biased, which also does sometimes happen. But actually arbitrators tend, when they're given the opportunity under arbitral rules, they tend to be able to agree the identities of chairs. I have never been unable to agree the identity of a chair with a co-arbitrator when I've been appointed as one. Never. A sole arbitrator. These are rarely agreed because counsel are too much at loggerheads. But arbitrators are one step removed. So while arbitrators can often agree chairs, counsel can relatively rarely agree sole arbitrators. Sole arbitrators then will lean their interests, so the hypothesis goes, towards the interests of an appointing institution, whatever those interests are, which is also an interesting question. Probably what those interests are the writing of the institution's rules into the larger litigant's future contracts, so that the London Court of International Arbitration wants people to put LCIA clauses into their contracts in the future. So we might imagine that a sole arbitrator will lean towards an institutional litigant more than the other way. That's a public choice theory hypothesis. Again, however, we're in danger of creeping back to my sinking to the bottom hypothesis that the whole system might be perceived from a public choice point of view as biased in favour of the rich. Another hypothesis. Now this one I think I actually have quite a lot of support for, personally. Procedural and jurisdictional issues are less decisive in the determination of arbitral outcomes compared to judicial outcomes, as arbitrators have inverse incentives from judges. It's better for them that cases go on longer. That's because arbitrators are paid more. And that's why arbitrators have an uncanny habit of upholding their own jurisdiction, whereas judges have an uncanny habit of finding that they don't. Now, I'm engaging in precisely the sin I cancelled you against just a few minutes ago, which is not to work in economics on the basis of mere stories and anecdotes. But that is my anecdotal experience. But these hypotheses should not be resolved by anecdote. They should be empirically testable. The worst branches of economics are those full of theories of symbols and unverifiable assertions. But there's a problem. You just can't get the data. My hypotheses could be tested, but you can't get the data because arbitrators cloak themselves in the veil of confidentiality. Maybe my public choice theory cynical hypotheses are justified. Maybe they're all false. But public choice theory may also, as applied to arbitrators, may also be a self-refuting hypothesis if we could access the data. The reputational damage done to arbitrators by public revelation of bias or other non-principle based behaviour might be displaced by its public exposure. Hence my tentative conclusion to this talk is a call for the abandonment of the principle of confidentiality, which in my view is much overrated. In my experience, parties to arbitration do not arbitrate because it is confidential. That is something which arbitrators like, not so much parties. Firstly, because arbitration isn't confidential. For all those of you who read Global Arbitration Review, there are endless newspaper articles about people starting proceedings, settling proceedings, winning proceedings, enforcing proceedings. Actually, arbitration is much more reported upon in the general news than is litigation. Because the textbooks over there of the All England reports, it is true, do not contain decisions of arbitral tribunals. But you know what? Nobody reads those textbooks. They're all looking rather dusty. Nobody reads them, and in particular, if people do read them, they're law school students. But arbitration is not a confidential process in the sense of being confidential for clients. No dispute resolution process is very confidential unless both parties want it to be, because there's no effective remedy for breach of confidence in an arbitral context. And generally, both parties do not want an arbitration to be confidential. The winning party wants it to be publicised, or the claimant wants it to be publicised in order to place settlement pressure upon the respondents. So confidentiality is an impossible myth. It's not actually what litigants want, it's what arbitrators want, because it hides their activities from the due light of public scrutiny. The overriding lesson, I suggest, of public choice theory is that its adverse indicators of government behaviour are mitigated in the light of transparency, since this assists electors in holding governments to principles-based rather than incentives-based decision-making, which is what we all want. The case for international arbitration to embrace the same approach is surely overwhelming. The electors in international arbitration are the litigants. And the bright light of transparency would assist both scholars, such as yourselves, in assessing the veracity or otherwise of the hypotheses, many of which are deeply dark and concerning, and, I hope, would refute them, because it would raise arbitrators' game, just as judges' games are raised by the possibility of their judgments being overturned or criticised or condemned in the literature. Arbitrators don't face that, and they should, because if they did, then the dark concerns I've expressed, which I'm trying to articulate in the language of public choice theory, would surely disappear. Thank you very much for listening to me. Does anybody want to ask any questions?
Just a quick question. You talk about empirical data, and I absolutely agree in this area, especially ADR, civil procedure, international commercial arbitration, there is that lack of empirical data, although Tom is doing a great job through his efforts in breaking that tradition. What kind of empirical data are we talking about? How would you get it? What are you essentially looking for?
I think there's a lot of interesting empirical data we could get. For example, we could ask how often arbitrators are appointed by parties, how often they're appointed by counsel, how often they dissent, how often they dissent in the direction of the party appointing them, and how often they dissent in the other direction. We could ask the same about sole arbitrators. Where large institutional clients arbitrate a lot, we could compare data about how often they win before certain sorts of sole arbitrators, before the chairs of certain tribunals. If we could collect that sort of data, for example, we could perform regression analysis. And we could say that arbitrator is biased and that one's not.
Do you think arbitrators would be willing to give that information? The reason why I ask is I've just come across a very recent 2016 English High Court case called Coftly, in which the arbitrator was appointed there as a sole arbitrator who'd been appointed on many arbitrations by one of the parties in the actual dispute. And the claimants got hold of this and they said, hang on, there's a danger of apparent bias, or there is apparent bias, not actual bias, apparent bias. So they sent this arbitrator, Mr. Bingham, from 3 paper buildings actually. They sent him a lot of questions and said, how often have you been appointed by this party? What are your financials?
Please don't defame him, because this is being recorded.
Oh, okay. No, it's a reported case.
Okay.
You can find it on Bailey and on Westall. So they sent him a whole list of questions. Stevens and Harwood were acting for the because they wanted the information to check whether there were conflicts under the IBA rules and under the rules of the Chartered Institute of Arbitrators, which they were relying on to say, well, actually, we have this right to do this. But the interesting thing in that case was the arbitrator was very defensive. He wouldn't answer the questions, and the judge went through all the correspondence, and he was very, very sort of defensive, not releasing the information that they were asking for, legitimate information under the IBA rules, for example, in order to deal with conflicts. So the whole, basically, the judge came to the conclusion that there was apparent bias because of the fact that he'd been appointed previously, his behavior during the correspondence between the parties, he was hiding information, he looked like, etc., etc. So my only concern is we go for empirical data and approaching arbitrators, which is, I think, is an excellent idea because that's what we need. We need more empirical data in this field. Do you really realistically think that arbitrators will be willing to share this information?
Arbitrators will have to be forced. I mean, of course they don't want to share this information. Yeah. That's the problem we've got. And so far, they've managed to keep it concealed. The problem you described, by the way, is a very common one. I recently had an arbitrator struck, I say recently, about a year ago, because I discovered by accident that he'd been appointed 10 times by the opposing party. And now, when you're nominated as an arbitrator, you get a form from the appointing institution saying, do you have any disclosures? Typically, you sign a box saying either I declare I am independent and impartial, or you sign a box saying I am independent and impartial, but I want to disclose all of the following things: A, B, C, D, E, F. Now, my approach as an arbitrator is maximal disclosure of everything. For example, I am sometimes appointed as an arbitrator by certain entities in a certain country, with which I have personal and social connections. And I mention exactly what those social and personal connections are. Because I think arbitrators ought to do that. And actually, I think they ought to be forced to. I mean, for example, or if I am appointed by council and I've recently instructed them to do a piece of work for me. These, by the way, are not disclosable under the current IBA orange list rules. I disclose them anyway, because I think I ought to do so that people can understand the nature of the relationship I have with appointing counsel and or with the client and or with a country, because there's often an international element to arbitration, ex hypothesi, and people ought to be aware of that. Most arbitrators do not do that. They tick box A.
Yeah, and I think that's what happened in this scenario. Tick box A, but later transpired that he'd been appointed X amount of times.
Well, I'm very sorry to say that since my experience, the 10 times guy, the first thing I do now is Google an arbitrator. when I've seen my opponents appoint an arbitrator, it's like Google their name and then the name of the appointing client and then the name of the appointing law firm, and I try to see if I can find anything. And you know the worst thing is, I usually find something. Now, I think all that should stop. I think the users of arbitration are going to have to force it to stop, and or judges are going to have to force it to stop. The English court attitude, in my view, has been not useful, which is to make arbitrator challenges historically exceptionally difficult. I think they should lower the bar substantially for arbitrator challenges in the absence of very full disclosure. And I would advocate redrafting, for example, the IBA red, orange, and green lists for precisely that reason. That might be one way of inserting some level of transparency into the process, at least vis-a-vis the litigants.
I have a question. Do you see any difference between, because you talk about international arbitration, but is there a difference between international investment arbitration, international commercial arbitration, or other branches of arbitration? So taking into consideration the individuality of each area of arbitration.
Well, there is a far greater public interest element in arbitrations to which a state or a state-owned entity is a party. I think that's obvious. The fact that the dispute is or is not about an investment, I don't think matters, particularly. But certainly where there is a sovereign involved, there is naturally a substantially greater public interest, which strengthens all the arguments I've made. There has traditionally been more data about investor-state arbitration. That's because there have been relatively few cases. I mean, relative to the whole world of international arbitration practice. The vast majority of arbitrations are commercial ones, of course. We sometimes, when we who love investment arbitration, get into a world of thinking that that is the beginning and the end of arbitration. It's not. It's a tiny part of it, to which much the same considerations, in my view, apply as I've been discussing in this talk. I think the reason traditionally there has been more data is firstly because sovereigns are involved. There is public pressure. There is public pressure upon sovereigns to release information about what they're doing. There's public pressure upon sovereigns because claimants want to publicise things more, because sovereigns are more susceptible to the pressure of publicity than are regular private litigants. That's why there's probably more data about it. It's also because it's a very small subset of international arbitration as a whole, it's easier to dig around, and more people. It's also high value, so there's proportionately you need fewer resources to obtain that information. There's a relatively small world of people who sit as investment arbitrators, and it's easier to track them down, and it's easier to talk about their work, and that's also reflected in some variance in the institutional rules, such as in ICSID.
But do you find that, because nowadays you do have a lot of arbitrators who not just work as in investment arbitration, they predominantly work in commercial arbitration as well. So if most of the cases in commercial arbitration are private or they're not publicized, you don't really have the data when it comes to the appointment in investment arbitration. You don't really have the data you need to assess whether or not an arbitrator is actually
I agree.
independent.
I agree. How could we change that? You know what we ought to be doing? If you have even the slightest shred of sympathy for anything I've been saying, and by the way, if you don't, that's because you think all arbitrators are perfect. If you have any shred of sympathy for what I've been saying, then we should be agitating, should we not, for massive exercises in changing institutional rules and curial laws in order to compel the publicisation of the sort of data and information you're referring to. That, it seems to me, would be a very valuable public policy initiative. Very valuable. Arbitration is increasingly the tool of choice in international dispute resolution in a globalised world. And presumably the reason we're studying it is because we want to make it better. How do we make it better? We need more data so we can assess hypotheses. And also because publicity is inherently a good thing, I suggest. How do we do that? Well, we have to be activists, and we have to agitate, and we have to run around and tell institutions and arbitrators and judges and other people that these issues are important, and that they ought to change their rules and laws to make the process more public. And we ought to be talking to litigants as well, because then they'll get something better than what they've got now.
Do you find that the Mauritius Convention could actually push towards a change in the current status of arbitration?
In what sense?
That it actually, you have a top-down system where transparency is promoted in investment arbitration, at least, irrespective of the institutional rules.
Well, I mean, somebody has to enforce conventions. if those principles are reflected in increased practice, in changes in practice on the part of institutions and arbitrators, or judges applying curial laws, then all the better. But what I'm suggesting is that there are institutional, structural reasons why that may not take place. The beneficiaries of privacy are not the parties, but the arbitrators. And that's why people outside the system have to push.
Thanks. A couple of questions. I mean, one that undoubtedly you have thought of and haven't answered, so I'll let you say. I mean, your assertion that it's arbitrators who want confidentiality. I mean, parties could have confidential arbitrations. They don't. So, I mean, if why is that then, as far as you're concerned?
That may be a path dependence issue. I do think, or it may be a principal agent problem. The fact is, well, LCIA rules have an express confidentiality clause. English curial law, there is case law confirming the confidentiality of arbitration. That's not, in fact, expressly referred to in a number of other countries' curial laws and a number of other institutional rules. So, one of the answers to your question is that the parties haven't thought about it, or haven't actually agreed confidentiality. The arbitrators have just taken it upon themselves.
I mean, having been in practice and done some arbitration, both ad hoc and institutional, I think, especially the ad hoc one that I worked on, confidentiality really wasn't even an issue or discussed. I think sometimes it's just implied that the parties want confidentiality.
One of the things would be, anytime you talk to anyone who knows nothing about arbitration, they will tell you that arbitration is confidential. So, I mean, one question of, simply because parties don't press for confidentiality doesn't tell you they don't want confidentiality.
Yeah.
Because they may simply assume it's arbitration, of course it's confidential.
And it's implied, yeah. So
That may be the path dependence issue. Is arbitrators run around saying, you know why arbitration is such a great thing? Because it's confidential, and you want that. And that sounds prima facie plausible, even though it's not.
Yeah, and I agree, because when you do look at the literature, the standard textbooks, the scholarly articles, whenever they're talking about arbitration and the advantages, the first one or second one, whatever it is, comes up is confidentiality, the fact that it's going to be protected. Sometimes it's just assumed, isn't it? I think, and I think it's actually quite a good idea to challenge that very notion. Is it actually something that the parties want, or is it something that's assumed and therefore not really thought about, and therefore it just comes with the job, or do they actually care about confidentiality, or are they more concerned about other issues of arbitration?
In some countries, arbitration simply isn't confidential as a matter of law. It's just not. It's private, in the sense that journalists can't walk into the hearing room. Well, we say that. I have an arbitration next week in Geneva. What happens if I just walk in with my legal team and say, and by the way, this is a journalist from Le Temps? Maybe I should try it.
Report back.
I'm not sure my client would like it, but which may go to prove your point. But it's a good question. I think in England, it wouldn't be difficult for the arbitration tribunal to say that person must get out.
Yeah.
I think in Switzerland, it would be much harder, particularly if I said this is a party representative holding a power of attorney. There aren't many cases like this I know of, but I'm not sure anybody has actually litigated this issue. Whenever I've seen the confidentiality of arbitration actually litigated, it's been completely inconclusive. Like arbitrators or judges saying, we completely condemn the leak of the pleadings in this case to the newspapers. Stop. Full stop. End of conversation. Because you can't prove damages. What's the loss? So it never goes anywhere, which is why the legal, even if, like in English law, there is a duty of confidentiality and it's set out in the law, it's mostly meaningless because it's free of remedy.
allowing that, I think probably everyone accepts that more information about arbitration would be a nice thing. Even people in the field think it would be a nice thing to know more. I mean, you even have sort of places like the ICC these days is going out of its way to disclose in various constrained ways. The question would be whether your proposed approach to solving that problem, to getting the information, is the right one. I mean, effectively, by getting all this information out there, the obvious downside would be people like you. As in, if you knew how many appointments I had had and where I was appointed by, you would be spending hours of your associate's time trying to find a link to get me off the tribunal if I was regarded as a bad thing for your case.
Well, doesn't that exactly support the hypothesis that arbitrators should be impartial and independent? I mean, right now I have to do that research because it's not mandatory for the arbitrators to disclose things, or not practically mandatory. In other words, they can tick a box and say nothing. And a lot of even very senior arbitrators do that, and in my view don't disclose things that they ought to. But if arbitrators are forced to do it, and then they're later find out to be lying, you see, the consequences for them are all the more draconian. And therefore I don't need to do the digging, and I can take a view, and I can say, okay, you know what, actually, I don't want that arbitrator on this case, because I think their connection with the issues, or with the parties, or with the counsel, is making my client a bit uncomfortable. So, you know what, would you mind, sir, please stepping down and having your counsel appoint a different arbitrator that doesn't concern my client so much? And the old myth, endlessly rehearsed by arbitrators, is arbitrators should resist facetious challenges. Nonsense. If someone has a concern about your appointment, even a small one, even if you might think it's a bit paranoid, you should recuse yourself, shouldn't you? Because you're undermining. I mean, if people fear that you may not be independent or impartial, that's a concern, because it's pertinent to the integrity of the process.
If it is indeed a concern.
If it
As
is.
in, I can very easily say, you've had these appointments and so on and so and so. I have absolutely no question that you're an independent and impartial person. I'm not going to say that. But I think that clearly they've appointed you because they think it's going to be helpful to their case. Therefore, I don't want you on that tribunal. I would much rather knock down everyone that comes along from them until they get to the point where they've just got someone that's really unhelpful to them in the slightest. So, I mean, you're presuming that people are doing these challenges in good faith.
Oh, no, they're not.
In which case, there is no problem with saying they shouldn't be doing it.
I tell you what, lots of arbitrator challenges are done in bad faith, and lots are done in good faith. The question is, where do you set the bar? If you set the bar higher, I do think you discourage this form of satellite litigation. I don't think you'd find more arbitrator challenges if you changed the rules in the way I'd like. I think you'd find the same number. Because sometimes your client just says, go and challenge this arbitrator just to waste 6 months. And you say, sure, that's what I'm being paid by now to do. I'd be delighted. Blah, 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 Mr. X is A, B, and C, all these terrible things. Yeah, well, Mr. Parrish's challenge is absolutely specious. Fine, I've been paid anyway. It's what my client told me to do. Who cares? Right? I mean, if clients want to play those games, because basically the reason you do these things is you want to buy time, right? Which is what a lot of dispute resolution is about. It's about buying time to pay, right? Which is fine. Litigation is a form of bank loan, right? I don't think you're going to reduce specious challenges by lowering the bar, and certainly you're not going to reduce specious challenges by increasing the amount of information that's available. And you know what? I think if you force arbitrators to disclose more, you know one group of people who are really going to hate it? Arbitrators. Oh God, these ghastly forms that this institution makes me fill in all these questions and answers, and I know this person socially. It's got nothing to do with them. Excellent. They're paid judges. Yeah? They should be put under scrutiny. If they don't like it, it's probably a good thing. I think that's probably what public choice theory might tell us.
And there we get to. I mean, what are the issues with public choice theory? Is precise, and again, it's not that the lack of confidentiality would not be a nice thing. The question again is whether it is the most effective way of dealing with the situation, which I think is more complex. Because one of the things that isn't factored into the sort of analysis that comes out of public choice theory, and now allowing that we're not trying to do it too simplistically, is the more the more psychological aspect of self-conceptions. So I mean, you're talking about sort of the idea that in an institution, in a government department, people will act in the way that their incentives set them up, all this kind of thing. There is more than ample empirical evidence that in certain types of government departments, where you have sort of like an established department that has evolved over time, you have an institutional self-conception. A certain type of person goes into that department, that they see themselves as doing a certain type of job. And that guides a lot of what they do, more than what we might regard as their financial or anything other incentives. If you take the notion of incentive broadly, it's sort of their incentive for self-satisfaction with their actions. And so taking that into arbitration, it becomes more difficult in modern arbitration because you don't have sort of like the coherent group. And a lot of the arbitrations that you do, it's some random lawyer that just got stuck on the tribunal and so on. They're not sort of part of any kind of community, arbitral community. They don't have a self-conception, all this kind of thing. But the question of sort of whether or not clarifying if there is an arbitral self-conception and sort of developing that as a way of guiding arbitrator behavior, as opposed to just saying we will just make everything available so people can just challenge you at the drop of a hat, and you'll be scared to do anything wrong, so therefore you're going to be doing everything much better, and so on. Which again, it's not that I think that wouldn't have positive effects. It's just not. Maybe it would not be the only thing that I would think would be desirable.
Is your thought that it might be corrosive to the sense of self-cohesion you've been describing in the imagined arbitral community that people are subject to greater scrutiny? Because if that's it, I don't think that is an attractive hypothesis at all. The idea that we destroy the principles of the club by letting other people look in through the windows at what we do, I don't like that idea.
No, I can argue that now.
Good. Okay. I'm just giving you a few thoughts in response. Certainly, there's some prospective value in the concept of self-recognition or self-esteem or something like this, or esteem in the perception of one's peers, or the sense of self-worth of the government official going into the established and uncorrupt Bismarckian government agency and running everything very properly and correctly. I wonder whether the empirical research you've referred to relates to government agencies which are entirely transparent and public. Because if they weren't, then probably the empirical research couldn't have been done.
They're Americans, right?
Right, who are wonderfully transparent. I mean, American government, everything is published on every website. I gave evidence to the US Congress the other day. I was told, your testimony will be on the congressional website forever. That's our policy. We never delete anything, not a single word. So be careful what you say, right? That is the American style. And thirdly, the self regard hypothesis, if I can call it that, kind of, the self-admiration
hypothesis on the end.
The self-admiration hypothesis as a motivator to public officials' behaviour can, of course, only be tested in conditions of transparency, which militates against confidentiality.
Not necessarily confidentiality of arbitration awards, though. I mean, what you need to do is get access to the people. So again, the question was whether the no one would question that increased information is a desirable thing. The question is just whether that is the way of doing it. So opening up all the information on everything isn't necessarily going to get you this kind of information. And if that kind of information is indeed something that has an impact. So for example, Jan Paulsen gets struck off a tribunal. I'm sure he could care in the slightest. He will have 14 other people calling him the next day offering him another tribunal. So I mean, that is going to have absolutely no impact on him. People with active businesses aren't really going to be that concerned because they'll get other things. On the other hand, sort of the fact that he gets actually knocked off a tribunal for actually being biased or something like this, that would be a concern because again, it has these broader social impacts.
So there are different sorts of, I think we agree, classic politician's line, I think we agree that there are different sorts of ways of promoting transparency. One might be to publish arbitration awards. Why not?
And it was
because
I have argued for it as well.
Yes, I mean, why not? I mean, because the other nice thing about publishing arbitration awards is that they can be subject to scrutiny and improvement of reasoning. Because good arbitrators aren't just people who come to things with an open mind, they're people who get cases right. To the extent we think that law is better off if it's closer to being a science than just a lot of people pushing and shoving and in a rugby scrum, then we want to be able to assess the quality of what they're doing, not just how the percentage of cases they're deciding in favour of claimants and respondents. That's particularly the case where arbitrators are not deciding huge numbers of cases. They're not deciding nearly as many cases as judges, and therefore statistical analyses may not be reliable as analyses about judicial actions. So reading their judgments awards might actually be quite a good idea, because then people like us can say, well, that was a very well written award, or that was a very bad one, and here's why. But it might also encourage and facilitate, in this sense, I do agree with the Lord Chief Justice. I think the rules on appeals of arbitration awards in England have become far too restrictive. It is a Section 68 or 69 application to the commercial court now is basically impossible. Virtually impossible, save in the face of the most egregious and outrageous wrongdoing. And even then, probably impossible. Section 67s, they're obliged to have a trial, and then they'll have a trial, and then they'll reject you anyway. Okay? I think that's a bad thing, because one of the methods of transparency and scrutiny of arbitrators and their awards and improving their game is some sort of appeal. Yeah. The argument against appeals is a wholly arbitrator manufactured one, right? Appeals are not nearly as expensive as trials, okay? But if they're a form of review, they're much cheaper because they're much shorter and they're focused on specific issues. They're a fraction of the total cost, and in many countries, the courts can do them quickly. But they should be more rigorous.
I think the other issue about appeals, especially in this country, is I think the senior judiciary have a vested interest in maintaining the commercial court in this country as sort of a world leading centre for people to come and litigate or even bring some arbitration. But I think that the mentality, having spoken to some members of the senior judiciary, is to try to maintain that idea that look, you can come to London as a seat of arbitration, and we will generally keep hands off, and that's why the judges tend to take sort of this restrictive approach that we take with appeals. So I think I agree with you. I mean, I think there should be wider. But I think behind the scenes, or when you speak to some of these judges who are always, promoting the commercial court and the roles building in London as, the epicenter of commercial business, international commercial business in London, they have that sort of approach, and they tend to be influenced by that, and they tend to want to maintain the status quo, let's take a restrictive approach to these appeals, because we don't want to scare commercial parties away from us, because otherwise they just go to France or Singapore.
You're certainly right. I've heard that attitude amongst many senior judges.
Yeah.
And it was a common... The problem with arbitration is competitive, right? Just as you say. There's people in Switzerland or Singapore or France saying, we don't get involved. You should come and arbitrate with us. And for a while, the English courts, they drank that Kool-Aid. Okay, they thought, yes, that's right, and we're I think at the apex of that now, where Section 68 applications are routinely being dismissed on the papers, even if they're very strong, and there's been gross violation of due process. That's very disturbing for me. And I think the argument that people choose their arbitral seats because lack of judicial intervention, I think it's nonsense. I don't think that's why people choose arbitral seats at all. Yeah. I think people choose London. Russian clients choose London because they've traditionally had a historical perception that English justice is fair, and because they speak English. Yeah. People choose Geneva as a seat of arbitration probably because they like to do their banking there, right? It's got very little to do with litigants' perceptions of the constraints of an appellate structure, because litigants don't care about that stuff because they don't understand it. They just want it done. And the problem is, how do we make it as good as possible? And I think more appellate review of whatever sort, but in a public fashion, even if it's just academic scrutiny, but preferably also judicial or arbitral appellate scrutiny, if you can write this into institutional rules, I think that's a good thing. If the LCIA were to put in an appellate system straight into their rules, because they've got a Section 69 exclusion clause in there, at least so it's been construed by the commercial court, if they were to put in an appellate system, I don't think they'd lose any business whatsoever.
Just one last point, just your views on this one, because the Court of Appeal or the Master of the Rolls has just recently, we were discussing this last week actually, because I sit on the Civil Procedure Rule Committee, and they've come up with a host of reforms for the Court of Appeal to decrease the workload on the Court of Appeal, and one of the proposals is that the right to a oral review after looking at the papers is going to be taken away. So the judge initially, you put forward your application for an appeal, judge looks at it and says, no appeal. The party who wants the appeal can then still put another application and say, I want an oral hearing. Yeah. So both parties can have an oral hearing, and then they can decide whether it goes to appeal or not. And if the judge says no after that, then there's no appeal. If he says yes, then so a different judge will decide on the oral application. But the idea now is, for the Master of the Rolls, we get rid of the oral appeal. We only do it on the papers.
So one-stop shop.
One-stop shop on the papers, unless there is, unless there are real public policy issues where there needs to be an oral appeal. How do you think that may impact on even those appeals which are made to the court?
Look, I'm thoroughly against it all. Okay. Look, appeals should lie of right, shouldn't they?
Because I think it's going to adversely impact on...
Appeals should lie of right. The moment when you need permission to appeal in a civil dispute in England was a bad day. And now we're cutting it back more and more and more. Okay? Appeals are an essential part of the integrity of the system, because first instance decision makers make mistakes. Usually the mistakes are because they've got so buried in the facts they've missed the bigger picture on any legal principles. And sometimes they've made procedural mistakes just because people make mistakes. And sometimes they have less benign intentions. But mistakes get made. Appeals are part of the structure and integrity of the system, and this proposal to cut down on the Court of Appeal's work is misguided. So the correct solution, of course, is to hire more Court of Appeal judges.
Well, but they don't want that.
They don't want that.
Ministry of Justice are saying, no money. And we've already discussed that to death, and we said, well, we need to do a campaign, and
money means less
Your
quality of
Kickstarter.
justice. Less quality of justice means England is less attractive,
Yeah,
and work can go elsewhere.
But
Simple
it's
as that.
interesting though, because once you get rid of this second stage, which was traditionally there,
Yes.
you know, for arbitration, it's going to restrict it even more.
Courts of appeals are virtually impossible now.
Yeah.
Because there is a provision in the Arbitration Acts and case law which says that an appeal from a decision of the High Court in relation to an arbitration can only be made if the High Court did not have the power
Yeah.
to make the order it did, which is incredibly restrictive.
Yeah.
So you have virtually no appellate system in England anymore. That's my analysis, and I don't think it's a good thing.
Yeah, and I think that proposal is just going to be the nail in the coffin. So it's just going to stay at the High Court level, and I think it's going to be extremely difficult to even get anything higher than that.
It's a shame, and England will pay in the long run for its failure to devote sufficient money to judicial resources. It's a mistake that England's made before. The solution, of course, is to charge people more money for appeals, so the system is self-financing.
So then what would you do under your approach for people who do in fact want their arbitration to be confidential? You just wouldn't allow them to have it?
I think probably. I haven't thought about that question carefully, but it's a good one. You might take. I mean, traditionally, let's take the judicial analog. I don't know the answer, but let's take the judicial analog. What if the parties to a litigious dispute in the High Court both write to the judge and say, we want the doors closed? Not for some reason of sensitivity, because it relates to children, for example, in the family division. We just want the doors closed. The judge would say no. I think rightly so. That's as good an answer as I can think of on my feet.
But I mean, then you get into the problem precisely that the arbitrator's incentives wouldn't be to say no. The judge is there with this role of looking at public justice and all that sort of thing, so they have a reason not to close things off. The arbitrators, on the other hand, I mean, my experience when I was in practice was precisely that. Yes, I'll let you escape in a second. Right? Was precisely that the first thing that the lawyers did when they got into a case was say, okay, let's sign a confidentiality agreement. So if you open that door, that's just what they do.
I understand, which is why you should tell them that they're not allowed to. There was a
But the arbitrators won't, I guess, is my point.
but then that might be ground for appeal. The origins, I think, of the recent English case law on the subject, post the Wolf reforms, was an employment tribunal which had locked the doors. So you couldn't. And they put on a sign. Well, I think they put on a sign saying confidential. And nobody actually wanted to get into the hearing. There were no journalists. It was just an employment tribunal case. Somebody had been sacked. And it was held, I forget whether it was by the Employment Appeals Tribunal or by the Court of Appeal, to which cases subsequently go. That in itself is a ground for the judgment of the Employment Tribunal to be overturned, because justice must be done and must be seen to be done. And that principle is not being respected. I mean, if we think that's a good principle, why shouldn't it apply to arbitration?
There was actually, I think it was when John Sarabji was here a couple of weeks ago, who was talking about certain cases where they hear them in really small hearing rooms, where there's literally just there's a seat for each of the parties and for the decider. Technically, you can go into that room, but there is literally not even a seat there for you if you wanted to go in and see.
The issue of open
Well,
justice.
then we should stick cameras in there.
Yes.
Well, there's an idea to do that.
I've never seen the arguments where you're dealing with a case without a jury, why there shouldn't be cameras in a corner. I can't see it. How is judges' behaviour going to be badly affected by the fact that they're being videoed? It's not. There's no conceivable reason why not.
So it's just the
Well, you did remind him earlier when he started speaking not to say bad things.
But he doesn't have the benefit of absolute privilege, which judges do.
The case is
When they're in court.
on Bailey and on Westgate. Just to make this public knowledge. So can we just say it's the principle of open justice? What you're arguing is simply make it transparent, make it open,
In which case, are you relying on a conception of arbitration as fundamentally part of state justice?
It is, to go back to my original analysis, the reason it attracts the attention of public choice theory is because it is an activity with significant public goods. It is not the visa arbitration. That's why it is regulated in the way it is. It has significant public goods, and therefore there must be an element of regulation in order to achieve those public goods. And public choice theory might help us to try to understand what sorts of regulation are more or less appropriate. And one of the most appropriate, I would say, is enforcing the principle of transparency.
Thank you.
Thank you very much. It's been a pleasure to talk to you.
Unless you had a question, Midori.
Right, thank you.
Okay. Chaps, I've got to get a taxi. I've got to go straight